In the world of law, sometimes you just can't wait. So what happens when your client's property is being held hostage and a full trial is, months or even years away? Well, today we're unlocking one of the most powerful tools for getting immediate relief, Rule 60 of the Rules of Court. You probably know it by its other name, Replevin.
So, picture this. Your client just bought a brand new car, all paid for, but a very unhappy ex-business partner is refusing to give it up. The main lawsuit to figure out who really owns it? That could drag on forever. So how do you get that car back, like, right now? That's the exact problem Rule 60 was designed to solve.
You can think of Replevin as the law's emergency key. It's what we call a provisional remedy, which is just a fancy way of saying it's an immediate action you can take right at the start of a case. It's all about getting that personal property back while the main lawsuit is still going on.
Okay, so let's get official for a second. Section 1 of Rule 60 defines Replevin as an action to get back specific personal property that's being wrongfully detained. Let's break that down. The two words you really need to focus on here are personal property, so no, this doesn't work for houses or land, and provisional, which means this initial seizure is just a temporary fix, not the final word on who the owner is. So how do you kick this whole powerful process into gear? Well, you can't just show up in court and ask for the property back. Nope, you've got to formally prove you have a right to it, and, just as important, you have to put up a financial guarantee. Let's walk through the 3 crucial steps.
The whole thing starts when you, the applicant, file for an order of Replevin, but that application has to be backed up by 2 absolutely essential documents, a sworn affidavit and something called a Replevin bond. If you don't have both of these, the court won't even give your request a second look.
Okay, now the affidavit. For all you bar exam takers out there, this is pure gold. These requirements are jurisdictional. Your sworn statement must have these 4 things, and you can remember them with the little mnemonic OWNV. You have to state your ownership, that the property is being wrongfully detained, that it's not under legal seizure or custodia legis, which basically means it hasn't already been taken by the government for taxes or as evidence in some other case. And finally, its actual market value. You miss even one of these, and your application is dead on arrival.
Next up is the money part, the financial guarantee. And the rule here is simple but super strict. 2x. You have to post a bond that is double, I repeat, double the property's value that you listed in your affidavit. This is not negotiable. And there's a good reason why. It does 2 things. 1, it stops people from filing baseless claims, and 2, it creates a fund to pay the other party for any damages if it turns out you were wrong.
All right, so once the court has checked your affidavit, approved your bond, and is satisfied, well, that's when it unleashes the power of the state. The court issues a writ of Replevin, which is pretty much a direct order to the sheriff.
The term they use in Section 3 is forthwith, and that means exactly what it sounds like, immediately. No delays, no waiting around. That writ gives the sheriff the authority to find that specific piece of property and take it into their custody right away.
And just how powerful is this writ? I mean, this quote from Section 4 says it all. If the property is hidden away somewhere and the person won't hand it over, the sheriff actually has the authority to break open a building to go in and get it. That just shows you how serious and, frankly, forceful this remedy can be. Okay, so the property has been seized. Is it game over for the other party? Oh, absolutely not. The rules of court are all about fairness, so the other side has a few ways they can fight back.
Now this number is so important, 5. From the second the sheriff takes that property, a 5-day clock starts ticking. The other party has exactly 5 days to make their move before that property is automatically given to the person who applied for it.
So, within that 5-day window, the adverse party really has 2 main options. First, they can challenge the applicant's bond and argue that it's not enough. Or, and this is the more powerful move, they can post their own counterbond, also for double the property's value, to get the property right back. But what if a completely different person, a third party, pops up and says, hey, that's actually mine? Well, they have a different path. They have to serve the sheriff an affidavit of their title, which then forces the original applicant to post another bond, an indemnity bond, to move forward. It is so vital to remember that everything we've talked about so far, the seizure, the counterbond, it's all temporary. The writ of Replevin does not decide who the true owner is. The final call on who has the rightful possession only happens after a full trial on the main case.
And here is another one of those concepts that's crucial, especially for exams. The judgment in a Replevin case is always in the alternative. What does that mean? It means the court will order the losing party to do one of 2 things. Either deliver the actual property, or, if that's not possible anymore, to pay its value in cash. It's one or the other.
So when the dust settles, what does the final judgment look like?
Well, think of it as the court's final accounting of the whole affair. It will officially declare who has the right of possession, it'll state the property's value, award any damages and costs, and, this is a big one for the people who put up the cash, it'll settle who is liable on those bonds that were filed.
All right, let's do a quick-fire round of the most important takeaways. If you're studying for the bar, these are the points you absolutely cannot afford to forget.
Okay, let's lock these in. 1. Replevin is for personal, movable property only. Got it? 2. The 4 affidavit requirements, they are jurisdictional. Get them wrong, the case is over. 3. The bond is always double the value, no exceptions. 4. That 5-day window to respond is absolute. And 5. The final judgment is always in the alternative, give back the thing or pay the money. These are the non-negotiables of Rule 60.
So, at the end of the day, what's the big takeaway here? Just think of Rule 60 as a really powerful, really fast, but also really technical key. It's designed to give you immediate relief to unlock property that's being wrongfully held, all while the slower wheels of justice turn to make the final decision on ownership.